The courtroom air was stale and thick with the scent of polished wood and indifference. Fluorescent lights buzzed overhead, casting an unflattering glow on the faces of those who had long grown used to the theater of justice. Judge Evelyn Monroe sat high upon the bench, her black robes draped like armor, her reading glasses balanced just so on the edge of her nose. At 56, she was the picture of formidable discipline, sharp-eyed, cold-voiced, and famously unforgiving of youthful arrogance. She didn't look up when the bailiff called the next case. State of Michigan versus Jordan Ellis. There was a pause as a young figure rose from the defendant's table. Jordan, 17, slight of frame and wearing a secondhand suit that sagged at the shoulders, stepped forward. The sleeves of his shirt were a fraction too short, and his shoes scuffed in places most people wouldn't notice. But Judge Monroe did. She finally glanced up, arching a brow, her lips pressing into the faintest trace of a smirk. "You're Jordan Ellis?" she asked, her tone saturated with disbelief. "Yes, Your Honor." "You have chosen to represent yourself?" The words were drawn out as if to savor the absurdity. Jordan swallowed. "Yes, Your Honor." The courtroom rustled with amusement. A few snorts escaped from the back row. Even the prosecutor, Clark Hastings, seasoned, suited, smug, allowed himself a chuckle as he leaned toward the jury box with theatrical calm. Judge Monroe leaned forward, fingers tapping rhythmically on the bench. "Mr. Ellis, this is not a school debate club. You are facing charges of grand theft auto and resisting arrest. This isn't a game. You could go to prison." Jordan nodded once, steady. "I understand the seriousness, Your Honor, but I've reviewed the evidence. I'm confident I can present my side." Her eyes narrowed slightly. "Confidence and competence," she said, "are not the same thing." Another chuckle from Hastings. "Well, if he insists," he muttered, loud enough for the room to hear. Monroe ignored him. "Very well, Mr. Ellis, but know this court is not lenient with theatrics. You want to play lawyer? You'll be treated like one." Jordan gave a slight bow of the head. "That's all I ask." And with that, the dance began. Prosecutor Hastings rose first. Every movement was fluid, practiced. He buttoned his jacket before stepping forward, addressing the jury with a mixture of confidence and boredom, like a man certain he was about to win a race against a child who didn't know how to tie their shoes. "Ladies and gentlemen of the jury," Hastings began, "this case is, quite simply, an open and shut matter. The defendant was caught near a stolen black sedan late at night, seen by an officer attempting to hotwire the vehicle, and then fled on foot when commanded to stop. We have witness testimony, video surveillance, and the arresting officer himself. The state will show that the facts are clear, the law is unambiguous, and the defendant's guilt is beyond doubt." Jordan didn't flinch. He sat quietly, pen in hand, scribbling something on a yellow legal pad. If he was intimidated, he didn't show it. He looked not at the jury, not at Hastings, but at the judge. Measured, calm, unreadable. Judge Monroe watched him, curious now, though still skeptical. The defendant's posture had changed. The slouch had vanished. His eyes, previously anxious, now carried the faint glint of something she couldn't yet name. Hastings finished his opening remarks with a theatrical flair. "We ask for one thing," he concluded. "Justice for us." Jordan stood. No theatrics, no flair. Just a young man in an ill-fitting suit facing down a courtroom that didn't believe in him. "Your Honor," he said simply, "I have no fancy opening statement. Just the truth. I didn't steal that car. I didn't run from the police to avoid justice, and I will show this court, step by step, why this case is not as open and shut as the prosecution claims." A quiet fell across the room. Not silence, but curiosity. Judge Monroe lifted her gavel, paused, then lowered it slowly. "Proceed, Mr. Ellis." And for the first time that morning, she wasn't smirking. The courtroom settled into a cautious silence as Prosecutor Hastings called his first witness. Officer Brent Dawson, a broad-shouldered man in his early 40s, with a buzz cut and a badge polished to mirror shine. He took the stand with the kind of confidence that came from years of arrests, convictions, and the assumption that his word carried the weight of truth. Officer Dawson, Hastings began, tell the court what happened the night of April 12th. Dawson nodded. At approximately 9:43 p.m., I responded to a report of a possible stolen vehicle, a black Toyota Camry parked near an abandoned lot off Gardenia Street. When I arrived, I saw the defendant inside the vehicle, leaning over the center console. When I approached and ordered him to exit, he ran. Did he resist when you caught him? Dawson didn't hesitate. Yes, sir. He struggled, had to be cuffed forcibly. The prosecutor turned with an air of finality. No further questions. It was David Ellis's turn. The young man rose slowly, the yellow legal pad in his hand now marked with circles, underlines, and short, sharp phrases. His expression had shifted. Calm, calculating, composed. He approached the witness box with a kind of quiet control that made even Hastings glance up. Officer Dawson, Jordan began, you testified that you saw me leaning over the center console. Could you describe how far you were when you observed this? Dawson leaned back slightly. Maybe 15 to 20 feet. I was near the front of the patrol car. The suspect was inside the vehicle. Was it dark? Yes. Was the interior light on? I couldn't say for certain. Jordan took a breath. So at night, from 20 feet away, without confirming whether the interior light was on, you claim you saw me inside the car, manipulating something you couldn't see? Dawson's jaw tensed. I saw movement. It was obvious what he was doing. Obvious to you, but not visible in detail? Yes. Jordan stepped back, then turned to the jury. Let the record show. This officer claims certainty without clarity. No tools were found on me, no broken glass, no forced entry, and yet he assumes guilt from posture alone. Judge Monroe raised an eyebrow. She hadn't expected that level of precision. Officer Dawson, Jordan continued, you also said I ran. When you first approached me, were you in uniform? I was in my jacket and badge. Was your badge visible? It was clipped to my belt. Jordan paused. So, to a startled person in a dark alley, your identification would have been subtle, perhaps easily missed. I identified myself, Dawson insisted. Jordan tilted his head. Can you confirm that I heard you? I can't confirm that. Jordan nodded once. Thank you, no further questions. There was a stir in the courtroom, not loud, but real. Murmurs of approval, something was shifting. Next came the vehicle owner, Ms. Ramona Clark, an older woman with nervous hands and a tight smile. She testified that the car belonged to her, that it had gone missing the night of April 12th, and that the police later recovered it in the same condition she had left it. No damage, no missing items. Jordan stepped up slowly. Ms. Clark, was your vehicle locked that night? I believe so. Believe, Jordan asked gently. She hesitated. I usually lock it, and there's a star, but I'm not sure. Did anyone else have access to your car? My son sometimes uses it, and my nephew Alex. I've given them keys in the past. Jordan turned to the jury. So the car may not have been stolen by force. It may have been taken, borrowed by someone with access. The prosecutor objected. Speculation. Judge Monroe paused. Sustained, but noted. Jordan nodded. No further questions. He returned to his table. His hands were steady now. Even the way he sat had changed, from defensive to assured. For the first time, Judge Monroe truly studied him, not just the facts, but the presence. There was something about the clarity of his language, the calm with which he dismantled assumptions that no teenage boy should have possessed. The jury watched him differently now. The gallery no longer smirked. Hastings fidgeted with his pen. Jordan Ellis had entered this courtroom as a defendant. He was becoming something more. Jordan Ellis stood at the defense table, shoulders square, breath steady. Around him, the courtroom pulsed with a new energy, an almost imperceptible shift in weight. Not just curiosity now. Respect was starting to creep in. Even the judge, known for her icy demeanor, hadn't interrupted his last cross-examination once. But Jordan knew the storm hadn't passed. The prosecution still had its anchor, the grainy security video, an image that, while unclear, had become the crown jewel of their case. "Your Honor," said Prosecutor Hastings, rising smoothly, "the state now calls Detective Raymond Holtz to the stand." A tall, angular man in his 50s, Detective Holtz had the practiced gravity of someone who had built cases for decades. He took his seat confidently. "Detective," Hastings began, "please describe the nature of the evidence gathered." Holtz nodded. "We obtained security footage from a business across the street, a pawn shop with a street-facing camera. It shows a figure entering the car in question shortly after 10 p.m. on April 12th. Does the video identify the defendant?" "No, the resolution is low, but the figure's build and clothing match the defendant's description." "And what happened after that?" "The figure sits in the driver's seat for approximately 4 minutes. Then the lights flash on. Moments later, a police cruiser arrives and the figure flees." Hastings folded his hands, satisfied. "Would you consider this footage strong corroborating evidence?" "Yes," Holtz said without hesitation. "Thank you. No further questions." Jordan rose slowly. Every word now had to count. "Detective Holtz," he began, "you said the footage is grainy?" "Yes." "And the figure's face isn't visible?" "No." "Is it possible that another person with a similar build and similar clothing could have entered that car?" Holtz frowned. "Anything's possible, but unlikely." Jordan walked slowly to the evidence screen. "Detective, I'd like to play a portion of the video." Judge Monroe nodded. "Proceed." The courtroom lights dimmed slightly as the footage played. The image was indeed murky, a figure in dark clothing approaching a parked car. The jury leaned forward. Jordan paused the video. "Detective, does this figure's gait, his walk, match mine?" Holtz hesitated. "I'm not an expert in gait analysis," he finally said. "Exactly," Jordan replied. "So you can't say under oath that this is me?" "No," Jordan turned to the judge. "Your Honor, with the court's permission, I'd like to call an expert witness, Dr. Kara Lanning, a forensic video analyst." Hastings was already halfway out of his seat. "Objection. This witness wasn't on the original list." Jordan didn't flinch. "This is a rebuttal witness, Your Honor. I received her findings less than 48 hours ago. Her testimony directly challenges the prosecution's central piece of evidence." Monroe paused. "I'll allow it, but tread carefully, Mr. Ellis." Dr. Lanning, a composed woman in a smart navy suit, took the stand and introduced herself. Jordan approached the podium like a conductor ready to direct a quiet symphony. "Dr. Lanning, did you analyze the surveillance video submitted by the prosecution?" "Yes." "In your professional opinion, can the individual in that video be conclusively identified as me?" "No," she said firmly. "The resolution is insufficient to make a facial or definitive gait identification. Furthermore, the lighting and angle obscure key features." Jordan nodded. "Did you notice anything else about the footage?" "Yes," she said. "A time discrepancy. The camera's internal clock appears to be off by 13 minutes, meaning the individual entered the vehicle before the time the police report states Mr. Ellis was even in the vicinity." Gasps spread across the courtroom like wind through dry leaves. Hastings tried to object but stumbled over his words. Jordan calmly turned to the judge. "Your Honor, if the video places someone else at the scene before I was anywhere nearby, and that person cannot be conclusively identified, then this footage is not evidence. It is conjecture. and it undermines the integrity of the prosecution's timeline. Judge Monroe blinked slowly. For the first time, she looked not like a judge sizing up a teenager, but like someone realizing she'd underestimated what she was witnessing. Jordan Ellis had not only defended himself, he had dismantled the state's most damning evidence with a precision most attorneys wouldn't dare attempt. He sat down, slowly, deliberately. In the room, it didn't breathe. It listened. By the time of the court recessed for lunch, the air felt different. No longer a teenager defending himself, no longer a joke in a hand-me-down suit. Jordan Ellis had shifted the axis of the room. When the court resumed, Prosecutor Hastings was rattled. His next witness, a forensic technician, was meant to reinforce the chain of evidence. But the earlier cracks were widening, and when Jordan objected to one of the technician's vague conclusions, with a direct citation from Michigan criminal procedure, the courtroom stirred with murmurs of respect. But Jordan wasn't finished. Not even close. He rose again. "Your Honor, I'd like to call my final witness, Mrs. Geraldine Ellis." The judge tilted her head. "Relation?" Jordan looked at the floor for half a second before lifting his gaze. "My grandmother." From the gallery, a woman in her late 60s slowly stood. She was tall, regal, dressed in navy with pearls and quiet poise. Geraldine Ellis took the stand not with fragility, but with quiet fire. Jordan approached with a tenderness he hadn't shown any other witness. "Grandma," he began softly, "do you remember what I was doing the night of April 12th? She smiled gently. "I do. Please tell the court." "You were with me," she said, turning to the jury, "from 6 p.m. until almost midnight. We were at the public library preparing for your scholarship interview with the Morgan Fellowship." The judge leaned forward slightly. "You're sure of the date?" Jordan asked. "I'm sure," she replied, pulling a printed email from her purse, "because I printed out the interview email confirmation that morning. I reminded you at dinner." Jordan accepted the paper and submitted it as evidence. "Grandma, did I ever leave the library alone that evening?" "No, I sat across from you the whole time. You even asked me to quiz you on Supreme Court rulings." The gallery chuckled faintly. "And when we got home?" "You stayed up another hour, said you needed to memorize the preamble to the Constitution backwards." Jordan smiled, but only for a second. "Thank you, Grandma," he said. "No further questions." The prosecutor stood slowly. "Mrs. Ellis, you're this young man's grandmother. Isn't it possible that your memory is colored by affection?" She didn't flinch. "My affection doesn't change timestamps. I have a library sign-in receipt and a parking garage entry ticket, both time-stamped. Would you like copies?" Even the jury smiled. The prosecutor nodded stiffly. "That will be all." Jordan stood once more, this time addressing the court directly. "Your Honor, in light of the witness's alibi, the time discrepancy in the video footage, and the testimony from Mr. Thompson earlier, I respectfully move to dismiss all charges due to lack of evidence and prosecutorial error." The courtroom froze. Judge Monroe was quiet for a long time. Then she leaned back, fingers steepled. "Mr. Ellis, I must say this is the first time in my 23 years on the bench that a defendant, let alone one without formal legal training, has moved for dismissal mid-trial and made me pause." She scanned the room. "I'll take this under advisement. Court is adjourned for the day." The gavel struck like thunder. As Jordan gathered his papers, someone whispered from behind, "That boy should be teaching law, not just studying it." But Jordan didn't hear them. He was looking at his grandmother, who simply nodded. Her eyes said, "You've already won something bigger than a verdict." The final day of trial began with the quiet tension of something larger than law, a moment when justice wasn't just being heard, but weighed. Jordan Ellis entered the courtroom with the same modest navy suit and the same quiet focus. No entourage, no law degree, just a teenager who had dismantled an entire prosecution using truth, logic, and grace. The judge called the court to order. "Before we proceed," she said, her voice calm but resonant, "I have reviewed the motions submitted by Mr. Ellis. I've also revisited all exhibits, witness statements, and procedural irregularities highlighted throughout this trial." She paused, letting the room absorb her next words. "It is my ruling that the charges of grand theft auto and resisting arrest be formally dismissed. The evidence presented does not meet the threshold for conviction. Moreover, this court finds that the defendant's rights were compromised by a premature assumption of guilt, flawed identification methods, and failure to investigate alternate suspects." There was no eruption of noise, just a deep, collective exhale, as if the courtroom had been holding its breath for hours. The prosecutor stiffened, but said nothing. The jurors looked relieved. A few even smiled. But Judge Monroe wasn't finished. She turned toward Jordan. "Mr. Ellis, when you first walked into my courtroom, I'll admit, like many others, I saw only your youth. I saw nervous hands, an ill-fitting suit, and I assumed you were out of your depth. I was wrong." A ripple passed through the gallery. "You didn't just defend yourself," she continued. "You reminded this room, every lawyer, every observer, even this bench, why the law must never become arrogant. You exposed bias without bitterness. You pursued truth with precision. And you carried yourself with a professionalism I have seen lacking in far more seasoned attorneys." Jordan didn't speak. He just nodded, eyes glassy, lips pressed together. The judge leaned forward slightly. "Have you considered law school, Mr. Ellis?" A few chuckles rose from the gallery. Jordan answered clearly, "Yes, Your Honor. I've started applying." "Then I look forward to the day I see you not at that table," she said, pointing to the defense desk, "but standing here as an officer of the court." She banged the gavel. "This case is dismissed. Mr. Ellis, you are free to go." But Jordan didn't leave immediately. He gathered his papers carefully, walked over to the prosecutor's table, and extended his hand. "Mr. Hastings," he said, "no hard feelings." The prosecutor hesitated, then shook his hand, saying quietly, "You were right to believe in yourself." Jordan exited the courtroom into sunlight. The media had gathered, of course. Questions were shouted, microphones thrust forward, but he didn't stop. Not to gloat, not to claim victory. He walked straight to his grandmother's car, where she was waiting with the engine running and a smile that had waited 18 years to be this proud. As they pulled away from the courthouse, Geraldine reached over and squeezed his hand. "Justice doesn't always show up wearing a robe," she said. "Sometimes it wears borrowed shoes and walks in with nothing but truth." Jordan looked out the window. "No," he said softly. "Sometimes justice walks in when no one expects it." Moral of the story: this is not just a story about a teenager beating the odds. It's a powerful reminder that courage is not about age, and wisdom is not always found in titles or degrees. Jordan Ellis stood against the full weight of the legal system, not with privilege or pedigree, but with preparation, integrity, and the unwavering belief that truth matters. He didn't just clear his name, he forced a courtroom to reckon with its assumptions. We live in a world where appearances still shape verdicts, where youth, race, or status often speak louder than facts. But Jordan's story reminds us that the law was meant to serve truth, not power, and that when one person dares to stand with clarity, they can recalibrate an entire system. And so whether you're wearing robes, badges, or hand-me-down suits, never underestimate the quiet power of someone who refuses to be dismissed. Because real justice begins when someone dares to speak calmly and without apology, without